नमस्कार, आप सबका स्वागत है। आज हम सब यहाँ एकत्रित हुए हैं एक बहुत ही प्रसिद्ध केस को प्रस्तुत करने के लिए, जिसका नाम है बालाजी राघवन वर्सेस यूनियन ऑफ इंडिया। इस केस में बालाजी राघवन याचिका करता है और उत्तरदाता है यूनियन ऑफ इंडिया। इस केस के मुख्य न्यायाधीश हैं ऑनरेबल चीफ जस्टिस AM अहमदी, ऑनरेबल जस्टिस कुलदीप सिंह, ऑनरेबल जस्टिस BP जीवन रेड्डी, ऑनरेबल जस्टिस NP सिंह, ऑनरेबल जस्टिस सागीर अहमद। The two petitions which have given rise to this issue were filed in High Court of Kerala and Madhya Pradesh Indore bench respectively. The petitioner filed the petition on 13th of February 1992 before the Kerala High Court. The petition filed under Article 226 of the Constitution, that is a writ petition, can be filed before any High Court within whose jurisdiction the cause of action arises either wholly or in part. He filed a writ of mandamus to prevent the respondent from conferring any of the national awards. The petitioner also filed a miscellaneous petition in 1992 before the Indore bench of Madhya Pradesh High Court, praying for the same relief. Whereas the Supreme Court of India upheld the validity of civil honors and stated that national awards do not amount to titles within the meanings of Article 18, Clause 1, and they should not be used as suffixes and prefixes. Bharat Ratna, Padma Vibhushan, Padma Shri, etc. denote state recognition of good work in various fields of activity by citizens of India. Therefore, they are non-violative of equality of status guaranteed by the Constitution of India.
Historical content. Did you know 1992 historical awards like Bharat Ratna, Padma Bhushan, Padma Shri were cancelled due to the two PIL were filed in the High Court of India? One in the Kerala High Court on 13 February 1992 by the Balaji Raghavan and another one in the Madhya Pradesh High Court Indore bench by the Satyapal Anand on 24 August 1992. To know the reason behind these cases, we have to go back in the history before the time of the Indian independence. In the British era, these titles were given to the people who impressed Britishers by their impressive work. Britishers gave this title before independence to some specific community in order to create haters among the people and to break the unity among the people. During British rule, power to confer titles were being abused for the implicit purpose and for corrupting public life. Let's start with the fact of Balaji Raghavan versus Union of India. Balaji Raghavan, the petitioner in the High Court of Kerala, filed a petition under the Article 226 of the Indian Constitution, sought by the way of writ of mandamus with an aim to prevent the respondent from conferring any of the national awards. Kerala High Court did not hear any oral argument or pass any interim order. The respondent transferred this case to the Supreme Court of India on October 29, 1993. A division bench of Supreme Court of India directed this matter to be posted before a bench presided over by the Chief Justice of India. The National Award were formally instituted in the January 1954. Article 18 of Indian Constitution refers to the abolition of title, and the Article 18 Clause 1 reads, "No title, not being a military or academic distinction, shall be conferred by the state."
Scene 1. The Supreme Court of India. The case of Balaji Raghavan versus the Union of India is in session. Let the argument begin.
Your Honours, may it please the court, today we stand before to seek clarification on whether the awards Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri should not considered within the meaning of Article 18, Clause 1 of Constitution of India.
Mr. Counsel, please proceed with your argument.
Your Honours, please refer to the text of Article 18, Clause 1 of Constitution, which reads, "Abolition of titles, no title, not being a military or academic distinction, shall be conferred by the state." My Lord, Article 18, Clause 1 prohibits the conferment of titles by the state with the exception of military and academic distinction. It does not define the words titles and distinctions. The background of this word title should be given the widest possible meaning and amplitude in order to give effect to the legislative intent. Since this is the only exception to the rule that has been carved out in respect of military and academic distinctions, it follows that all other distinctions are impliedly prohibited. Moreover, the framers of the Constitution had intended to do away with the practice followed by the British of conferring various titles upon Indian citizens who carried favors with them. This practice and recipients of the titles had earned the contempt of people of pre-independent India, and hence such pernicious practices were proposed to be prohibited in independent India through this provision.
So, Council, don't you think that conferring of national awards is one of the most important mechanisms to reward meritorious citizens, the service towards nation?
My lord, the national awards make distinction according to rank. They are divided into superior and inferior classes, and the holders of Bharat Ratna have been assigned the ninth place in the warrant of precedence, which indicates the rank of different dignitaries and high officials of the states. The several recipients were following the practice of appending these awards to their names, using them as titles in their letterheads, publications, and at public functions. This practice has continued unabated despite the fact that the government had issued a press note in 1968 prohibiting such conduct. All these factors have resulted in the creation of rank of persons on the basis of recognition by the state, in the same manner as was achieved by the conferment of nobility during the British rule.
Council, any specific provision of the Constitution that supports your argument?
Yes, my lord, it is clearly violation of Article 14 with the preamble to the Constitution, which guarantee every citizen equality of status. And my lord, there are no objective guidelines for the manner in which recipients are to be chosen, and over the years, these awards have degenerated into rewards preferred by the powers, that is, the government of the day, in great numbers to those who serve political ends. Your lordships, the word title in Article 18, Clause 1 is used in an expansive sense to include awards, distinctions, orders, decorations, or titles of any sort whatsoever except military and academic distinctions.
After hearing the counsel of the petitioner, the limited issue for the consideration of this constitution bench is whether of the awards can be challenged as violative of Article 18, Clause 1, and secondly, whether the Article 14 of the constitution is violated or not.
Council of the respondents, please proceed with your submissions.
Your Honours, respected counsel for the petitioner is mistaken in his interpretation of the word title in Article 18, Clause 1 of the Constitution of India. This court may please refer to the latest edition of the Oxford and Johnson's Dictionary hereby submitted. Your Honour, if we refer to the ordinary meaning of the word title on pages 765 and 668 of both the dictionaries respectively, the word title means a title of honour, rank, function or office in which there is a distinctive appellation. An appellation is a name or a title by which a person is called or known, something which is normally prefixed or suffixed, for example, Sir, Nawab, Diwan Bahadur, Maharaja, etc. Your Honour, it is these appellations which violate the concept of equality by creating a separate class and which is sought to be interdicted by Article 18, Clause 1 of the Constitution of India.
Counsel, what makes you say that the title National Award is not conferred by the distinctive appellation violating the Code of Equality under Part 3?
Your Honour, national awards are not titles of nobility and are not to be used as suffixes or prefixes to call them a distinctive appellation. In this regard, a press note was issued by the Government of India on 17th of April 1968, making it clear that civilian awards should not be attached as suffixes or prefixes to the names of awardees to give them the appearance of titles. Moreover, Your Honour, almost every country in the world follows the practice of conferring meritorious awards on their citizens for giving meritorious services to their nations, and they do not violate their concept of equality.
Is relevant to ours?
Your Honour, it is of utmost relevant to us because the constitutional provisions of other countries are analogous to our 18 Clause 1 of the Indian Constitution. There also, orders, decorations, distinctions, as well as titles are intended to be prohibited, but separate mention is usually made for conferring national awards. For example, Article 73 and Article 109 of the Danzig and Weimar Constitutions respectively. Your Honour, to endorse this point, may I please submit before this court the views of Sir B.N. Rao, who was the chairman of Prime Minister's Committee on Awards and Honours of 1958, as well as he was the member of the drafting committee. Your Honour, you may please refer to Article 1, Section 9 of the US Constitution. which forbids granting titles of nobility but certainly allows decorations such as Congregational Medal of Honor and Distinguished Service Cross.
What are the guidelines that control the manner of selection of a receiver of these awards?
Your Honor, regarding the entire guidelines for the selection process, a copy of the communique from the Ministry of Home Affairs has been duly submitted to you, Your Honor, on page 30 of the case file submitted.
Counsel, do you have any other submissions?
Indeed, Your Honor, just one last submission at hand. The words not being military or academic distinction in Article 18 has been used by abundant caution by Constitution framers. This is because military or academic distinctions like general, colonel, professor, Mahavir, BA, etc. These titles do carry suffixes or prefixes, and so they are expressly exempted from the application of Article 18 of the Constitution of India. The obvious logical corollary of the above fact, Your Honor, is that the distinctions which do not contain these suffixes or prefixes, they will not be affected by interdiction of Article 18 Clause 1. This argument is supported by relevant parts of the discussions in the Constituent Assembly debates that led to the framing of Article 18 Clause 1, which has been humbly submitted, Your Honor, on pages 15 to 25 of the case file delivered to you.
Thank you, counsel. This case requires the careful consideration of constitutional provisions. We will reserve our judgment, then reconvene. Now, I would request Mr. Santosh Hegde, Senior Counsel, to act as amicus curiae to present his views on this case. According to me, my lord, the fact that these awards are being grossly misused had occasioned one of the writ petitions. Thereafter, the relevant parts of the discussions in the Constituent Assembly, before submitting that it is clear that the Constitution does envisage a situation where meritorious services rendered by individuals are to be recognized by the state through the conferment of awards. However, to avoid the criticism of creating a separate class, it needs to be ensured that these awards are not used as prefixes and suffixes. The submission of the learned Attorney General that the words military or academic distinction had been used by the way of abundant caution. Commenting on the misuse of these awards, the maximum number of awards that can be conferred should be specified. I also felt that ordinarily public servants and civil servants should not be eligible for these awards unless there are extraordinary reasons.
Now, the final judgment shall be pronounced by the Chief Justice of India.
After listening to both the councillors and amicus curiae, we may now refer to the views which were referred by Sir B.N. Rao, who was the chairman of the drafting committee as well as the chairman of the Prime Minister Committee on the awards and honors. He pointed out that titles does not necessarily include all the orders as well as distinctions. He stated that in Constitution, where all the orders, distinctions as well as the titles are prohibited, separate mention is there for the national awards. For example, the Article 73 of the Weimar Constitution and Article 109 of the Danzig Constitution, Article 14 of the Constitution of Japan, and there are several provisions in other constitutions like the Constitution of the Ireland, Philippines, and Iceland. The principle of equality is violated by hereditary titles of nobility because they establish a distinct, recognizable class which is separate from the rest of the society and have access to unique privileges. Titles that are not hereditary in nature have the same impact but to a lesser amount. Constitution makers' sincere intention was to avoid a repeat of similar situation which was prevailing in the pre-independent area, that is during the Britishers' time. So, from the above discussion, it is clear that in enacting Article 18 Clause 1, the framers of Constitution sought to put an end to the practices which were followed in the Britishers' era. They therefore prohibited the titles of nobility and all other titles which carries the suffixes and prefixes because these creates a distinct and unequal class of the citizens. They, however, mandated that honors conferred by the state should not be used as suffixes or prefixes. Thus, national awards are not violative under the principles of equality. Article 14, which is provided us by the Constitution of India. There is another article, that is Article 51, which talks about the fundamental duties of every citizen. So here there is a special subclause, Article 51A, subclause J, which talks about and which exhorts every citizen to strive towards the excellence in all spheres of individual and collective activity, so that the nation constantly rises to the higher levels of endeavor and achievement. Therefore, there should be a system of awards and decorations to recognize excellence in performance of these duties.
We have all heard the opinion proposed by A.M. Emery, CGI. I agree with the Chief Justice that Bharat Ratna, Padma Awards are not titles within Article 18 of the Constitution of India. The awards can be given to citizens for exceptional and distinguished service rendered by them in art, literature, science and other fields. These awards are national in character and only those who have achieved distinction at national level can be considered for these awards. The Padma Awards have been conferred on the businessman industrialists who have multiplied their own wealth and have hardly helped the growth of national interest. Persons with little or no contribution in any field can be seen masquerading as Padma awardees. It was recommended that awards should be very sparingly and only on the ground for outstanding merit. They should not be made merely because there happen to be vacancies in particular category. The note clearly suggested that the number of recipients in various awards must be restricted. Therefore, to ensure that the Padma Awards are truly in nature and above party political considerations, I suggest that a committee at national level be constituted by the Prime Minister of India in consultation with the President of India.
After hearing all the facts and arguments, I conclude that national awards do not amount to title under Article 18, Clause 1, and they should not be used as suffixes and prefixes. Case dismissed.